SJC-12084, Commonwealth v. Donald Calvaire.
Good morning, Mr. Baruch, Ms. Eisenberg.
Morning. Good morning, Your Honors. Attorney Baruch with the Committee for Public Counsel Services. With me is Beth Eisenberg. We represent Donald Calvaire. This case brings two principal issues before the court. Both relate to Donald Calvaire, who, by all objective indicia, if competent, would be sentenced to a maximum sentence of 2.5 years in the House of Correction, but has been in custody at either the Suffolk County Jail or at Bridgewater for the last 4 years. The first issue is whether the Chapter 123.16f statute gives Mr. Calvaire the benefit of House of Correction time being used as a measuring stick for his dismissal date. The second issue is whether an interpretation of that same statute that would instead require him to be detained for half of the state prison sentence is in derogation of his rights to equal protection under the law.
On the first issue?
Yes.
Let's say on this record, for the sake of my question, it is clear that he was not going to be indicted. How is the Department of Correction, or whoever's trying to deal with this, going to be able to figure out whether or not there's going to be a presentment of a case to the grand jury, whether a district court might decline jurisdiction? How's that going to work?
That's an excellent question, and I would suggest the best way for this court to achieve that is through its superintendent's power. You'll see that there's a form that's submitted by the judge in the district court, because this issue really relates to people in district court charged with concurrent felonies. There's a form that is sent that informs the Department of Corrections of the information that they need in order to calculate what the expected halftime is.
When is it sent?
Well, according to the statute, it's sent at the time of the 16C commitment, and that form is on page 55 of the impounded record appendix.
So when, in this case, was it sent?
In this case, it was not sent until actually January of this year on the defendant's request. And I have spoken, I tried to look into speaking with other attorneys about when it's sent, and it seems like it's often sent upon the request of a defense attorney in practice. But in terms of what is supposed to occur based on the statute, it looks like on a Section 16C commitment, by that point, a form is supposed to be sent. That doesn't mean that that form couldn't be revised. For example, if the objective indicia about what's happening to the case were to change, that certainly doesn't mean that a judge couldn't reconsider and send a different form. But I think
what about the interest in uniformity? The problem with your approach is that not everybody will be treated the same under the statute. So why don't we have a rule that says it's the highest sentence for the most serious crime, and that applies to everybody. So there's no discretion in the district attorney to have play a role in who gets treated how. Everybody is treated the same.
Well, I would suggest that incompetent defendants should receive the same kinds of benefits and treatment as competent defendants. And competent defendants are not all treated the same either, because there's some competent defendants who the Commonwealth has and they can choose to indict or not indict different defendants who are competent or incompetent, actually. But in terms of incompetent defendants, they're not receiving the same benefits that their competent counterparts are receiving. For example, there could be a case in which, and it's common, that there's a case in which someone's initially charged with a felony that is a bind-over felony that only has jurisdiction in the Superior Court, whether that's a second and subsequent drug offense or an unarmed robbery or something of that nature. And the Commonwealth comes in and reduces the charges to a larceny from a person or to a first offense. And they reduce those charges specifically in order to keep the case in the district or municipal court and allow final jurisdiction there. if this court were to say that only the state prison calculation could, or only the state prison sentence could ever be used in those calculations, it would mean that where the Commonwealth had specifically come in and done everything they could to try to keep the case in district court, where a defendant is incompetent, they would be facing a more significant
But wouldn't, I
time.
mean, doesn't the statute have a escape valve for that? Because it says, you know, you can do something different if the interest and justice should require it. And it would seem to me in that kind of case, why couldn't the defense counsel come in and say to the district court judge, look at what they've done, here we are, you really, the interests of justice say you should be using the, you know, half of the district court sentence at that time.
Well, and that's actually one of the arguments raised in this case as well. That was raised both below and at this time. And it's a two-part analysis. One is about whether there's a half-time calculation based on the 2.5 years in the House of Correction. There's also the fact that Mr. Calvaire has outserved the 2.5-year maximum. So that's certainly a second claim we make in this case. But in terms of, I think what that really goes to is actually looking to those objective indicia. So in a situation where you are looking to say, did the Commonwealth in fact made clear their intent not to indict, and you'll see that there's a...
Am I wrong that there's a due process line of cases, I think similar to what Justice Watson is saying, that there's a due process line of cases that allow someone to get out from under the statutory maximums in extreme cases?
If you're referring to the Jackson versus Indiana case?
Yes.
Yes. That certainly a claim made here as well, that Mr. Calvaire is, because he's, and that relates to his having exceeded 2.5 years incarcerated in this case. But in terms of the statutory language that relates to 16F and being charged in court,
I guess the problem I'm having is Foss and Chubbuck were both statutory interpretation cases that involve multiple offenses, as you certainly well know. How is this case not controlled by Foss and Chubbuck?
Foss and Chubbuck are different from this case in a couple of different reasons. One is that neither of those specifically interpreted the meaning of that in-court language that we focus on. But the second is that in those cases, in the Foss case, it's explicitly stated that the defendant would have been indicted, but for the finding of lack of competency.
It said that, but I must say I didn't understand why. I mean, there was nothing about the charges that meant they couldn't stay right where it was.
And it's listed in a footnote in the case. And
I know it is, but it doesn't.
I'm not sure what analysis was done there, but here it appears that if the analysis that we're proposing related to looking at the objective indicia in the case, analysis of that objective indicia, it appears that court would have found.
What is objective indicia? I didn't understand that.
So what we're asking this court to do is to empower a district court judge or a municipal court judge who's in a very good position to know what types of cases typically are and are not indicted, to make that determination of what objective indicia are. In this case, some of the objective indicia I would suggest are attempts to engage in plea colloquies, setting of trial dates, filing of pretrial conference reports, and in the fact that it wasn't indicted for the long period of time that it wasn't indicted, even given that there were periods of competency alleged in the record.
I think we have to assume
Mr.
that it was
Calvaire.
a district court case, given that it was scheduled for trial 2 or 3 times, right? There's no doubt it was going to be kept in the municipal court.
Right, this case appears to have every objective indicia that it was to be kept in the district court.
Right.
There are other indicia one could look at, such as a reduction from unarmed robbery to larceny from a person charge, a statement from the Commonwealth that they don't intend to indict. I mean, I think all of those are indicia that a judge would need to make a factual
Well,
determination.
what about the language in Foss that says we don't concern ourselves with the charging instrument? It's we don't concern ourselves with the charging instrument with good reason, I think is the language. So if you're looking at whether it's a complaint or an indictment, that would not be the way to distinguish the cases, would it? The fact that it's held in the district court wouldn't make any difference under that analysis.
That's the way that the issue turned in Foss. I would suggest that you're in a position to analyze that in-court language that was not presented in Foss as a reason that in-court language would be completely superfluous if it just said the defendant is charged in court, because the charges are always going to be charges in court. So the question is, which court is the defendant?
So it's a statutory interpretation issue, and the issue is whether or not it's tied to jurisdiction or to the crime.
Well, this court is needed to clarify that issue, I think, in reality. And our position that looking to the objective indicia of where the case was to remain, I would suggest is the only way that that in-court language makes the most sense, other than looking.
Where Justice Hines is concerned, though, if it's tied to jurisdiction, how's there going to be any uniformity or fairness, and what's going to happen to how this is going to play into executive branch charging decisions?
Well, not doing an individual analysis is going to lead to situations like this that are in derogation of the equal protection rights in terms of comparing a defendant like Mr. Calvaire to a competent counterpart who would have, Mr. Calvaire, the record indicates, he wanted to plead guilty at points in the case to receive the maximum sentence of 2.5 years in the House of Correction. His competent counterparts could have done that, but he could not.
So you mentioned, to my knowledge, the issue that the interest of justice should justify a shorter commitment has not been made to the court below, has it?
Has that been raised below? That was raised below, and it was raised in the motion to dismiss that this appeal comes from, and it was raised in the hearing before Justice Coffey.
Okay, so are you, I don't recall in your brief anything that says that the judge abused his discretion in rejecting that. Is that what you're arguing here, that there was that even if you do not prevail in your objective indicia theory, that we should focus on the House of Correction maximum where the person is likely to be charged in the House of Correction, that the district court judge should consider that in deciding whether in the interest of justice it should be reduced?
We don't argue specifically that the judge abused his discretion, but our argument, part 3, is that the defendant is entitled to a dismissal on the interest of justice, and that begins on page 44 of our
But this
brief.
would not be is it a dismissal if the judge says he's completed, that the interest of justice say he should be committed for no longer than a certain period of time? Does that result in a dismissal, or simply say that he's essentially served the maximum possible sentence under the statute, or maximum possible sentence that I think is within the framework of the interest of justice?
So section 16F has 2 parts. The first part is a dismissal based on serving half of the maximum sentence, and the second part is a dismissal based on the interest of justice. So if the judge were to analyze and say, based on the interest of justice, having served 2.5 years, it's really not fair for him to continue being served, he would have had that option of dismissing the case under 16F, which is what we're arguing in our brief as following our argument about the statutory interpretation of the Constitution.
That's your alternative theory. Your first theory is that, as a matter of law, the 30 months divided by 2 is the maximum possible, and then your second argument is that even if you don't prevail on that, that the judge abused his discretion in not considering the fact that this case is a House of Correction case and not reducing the length of the incarceration from the maximum. That's basically what your alternative argument is.
Right. The argument that the statutory interpretation compels using House of Correction time as part of the calculation, and if the language is not clear on that, then it's constitutionally required to be interpreted in that way in order to avoid an equal protection concern.
But on the equal protection, you compare a competent versus an incompetent defendant, but the fact is the competent defendant, just to take the example you used earlier, yes, could have pled guilty to 2.5 years, but he would have a guilty finding on his record. This defendant will not.
That's true. And to the extent that an incompetent defendant remains incompetent, There is not a way that a guilty finding could appear, but
But
I would,
I guess I'm just saying there's a little apples and oranges problem there, isn't there? I mean, in terms of equal protection?
they're not exactly the same in that particular way, but the fact that Mr. Calvaire is in a position of having been detained and had this case open for that much longer while in custody puts him in a position that's actually worse than someone who received, for example, a guilty in time served.
Okay, Mr. Gaziano, Judge Gaziano, do you have a question? Thank you.
Thank you.
Ms. Jordan, good morning.
Good morning. May it please the court, Darcy Jordan on behalf of the Commonwealth. There's only one workable interpretation of 16F as affirmed by this court in Foss, and under that interpretation, the actions of the district attorney do not matter, nor does the final jurisdiction of the court where the charges are pending matter. It's simply the maximum sentence allowable that pertains to the crime as defined by the legislature. Now, 16F, it applies to all crimes and addresses all crimes. It does not carve out an exception for cases that have final jurisdiction in Superior Court, does not carve out an exception for concurrent crimes as we're addressing today. And that is very important because if we are to interpret the statute to mean that the maximum sentence has to be one that the court may actually impose where the crime is pending, that would result in defendants who are charged in district court with crimes with final jurisdiction Superior Court only, they would not be within the scope of 16F. A calculation couldn't be made, and the case would have to be dismissed upon a finding of incompetency. It's simply not workable as the legislature intended it to work. Now, the way
Sorry, I lost the last piece of the argument.
that
The fact it's unworkable. They would.
it's unworkable.
Because you think the indicia of, the objective indicia are too vague, or because the DA could, if it wants to, simply indict the person if they're unhappy with that finding?
Well, objective indicia has no place in the interpretation of the statute. No place does the statute talk about the district attorney in its discretion. Frankly, the district attorney has no discretion in altering what the maximum sentence allowable is once that complaint issues. That is defined by the statute, and no matter what the DA does, indict or decide not to indict, that maximum sentence is static.
But you, what do you agree that the last sentence of the statute about the interests of justice offers a vehicle in a case such as this, or a case where the objective indicia are that the district attorney is not going to indict, to actually, for the judge to consider lowering the time that this, incompetent and looking to be not going to change, incompetent defendant is there?
Well, again, I do not think whatever the DA does, it doesn't change the equation, but I do think the interest of...
But it may change the equation on a case-by-case basis about what the interests of justice are. That's all I'm saying.
Well,
I'm sorry, finish your answer.
I think the interest of justice section really is a balancing, and I think the whole statute really attains at balancing the equities of a defendant having a case pending against them with the interests of the Commonwealth. And the interest of justice is a safety valve, and it does address that, especially in cases involving incompetent people that have mental health, that it's a murky water, and that interest of justice is the ability to present specifics to that defendant, specifics to that case, for a judge to rule that in the interest of justice, that case should be dismissed.
Clearly, in this case, because it was scheduled for trial 2 times or so, right?
Yes.
There's a pretrial conference scheduled for trial. This was going to be a district court case. I don't think you can dispute that. If the defendant wanted to plead guilty to the maximum, I want my 2.5 years. I want to plead guilty. Don't you think there's an interest of justice dismissal if he has served already that amount of time?
Well, I
Where
think...
if he was competent, he would have gotten his 2.5 years and been done with it?
Well, I think we have to take a step back because he's not in custody in the way we talk about competent defendants. He's civilly confined.
Might dispute that being in Bridgewater behind bars, but...
Well, I do think it's important to look at that separation for the interpretation of 16F, because the way the legislature designed it was that civil commitment, if somebody's mentally ill and dangerous, runs absolutely separate and apart from the criminal charge. So in this case, the defendant's confinement, if you will, is not in any way associated to his criminal
It's a
case.
deprivation of liberty. You'd give me that, right?
Sure, if there, well, I think not, because I think 16F is not contemplating a sentence, it's contemplating a dismissal. So to say the liberty interest is at issue, I think is a misnomer.
He comes to court in a prison van, right? In handcuffs?
Well, I think that's a separate evaluation about if Bridgewater is an appropriate place for a mentally ill and dangerous person.
But, what I'm getting at is a judge looking at the interest of justice could figure out that the DA is not going to indict the case. It was on for trial. This person has been either held or civilly committed for 2.5 years, and were he competent, the case would be over.
Absolutely, but I think it's just a misnomer to treat his civil commitment as if he was serving a sentence. Because
If the case were over, if it were dismissed, he'd still be civilly committed.
Yes, Your Honor, because the way the 128, strike that, is 123 is designed, there are actually two parallel lanes. And if you will, 16C, the way that this defendant became before the court, is really likened to an invitation to the civil commitment. And the criminal case is running parallel to the civil commitment. So in the event that his case is dismissed, it does not prevent the superintendent of a DMH facility.
Already a civil commitment that's going on right now that hasn't expired.
That's right.
Goes for another year.
That's right. Independent of the filing of this petition.
But is there any reason in this case, if I understand correctly, the using the 10 years, the DOC calculation is June or July of this, is it this year?
I must admit, on page 36 of my brief, the dismissal date should read July 2nd, 2017, not May 2nd of 2017. So his case right now is to be dismissed July 2nd, and his
Of 17?
of 17, and his
And so since he's, at the moment, civilly committed for until June of 17?
That's right, Your Honor.
Is there any reason not to, I mean, he's now had all this time. Is there any reason, assume you win on interpreting the statute, is there any reason why this case shouldn't be dismissed?
I think that would have to be remanded before the court for finding an evidentiary hearing about his last mental health evaluation. I
Understand it, on March 3rd, 2016, he was found incompetent.
He was. He was. So no, there's nothing that would prevent an additional ruling or finding thereafter based on the evidence. No.
But there are folks who are incompetent but not so dangerous as to be civilly committed.
Absolutely.
So I'm not saying he falls in that category, but if he did, would it be fair to keep, if he did, if he was among those who were incompetent for reasons, say, of mental inadequacy, but was perfectly harmless to himself and others, he would, upon release, not find himself civilly committed. He'd be put probably in a group home. Is it fair for somebody who would otherwise have faced only a 2.5-year sentence to potentially now face twice that? Because the person is incompetent because of intellectual inabilities or some other reason for incompetence?
Well, I think if we interpret it that way, I think it calls for the problem that Foss addressed, meaning that if any case of concurrent jurisdiction, the Commonwealth is going to have to indict it. So if to play that out, that would mean, well, for the Commonwealth to benefit from the outermost number, it would indict the defendant.
No, I mean, why wouldn't it go to the individualized determination?
Well, I think for the Commonwealth to benefit from having its interest in adjudicating the case, in monitoring an incompetent defendant, and essentially seeking justice for the victim in this case, it would want the outermost limits. And I think the legislature, by tying the equation to the crime and not the actions of the district attorney and the final jurisdiction of the court, actually contemplated that and gave the Commonwealth the outermost limits to pursue its interest, and then balancing that with the defendant's right to not have a case pending over it for an indefinite period of time.
this situation with this interpretation of 16F, it puts defense counsel in the district court in an incredibly difficult position, difficult ethical position, and difficult client attorney position, because you have a concurrent felony, say malicious destruction of property, which in certain circumstances has a 10-year maximum. And there's an issue of competency. And the attorney has certain ethical responsibilities, but the case is probably going to be probation or maybe even dismissed. And if there's a competency report, they may be held up to 5 years.
But again, when you say held, do you mean civilly committed?
I understand. No, I understand. That's why I differentiated the two with my earlier point. But it's an incredibly difficult and unfair situation where you've got a defendant who might have serious competency issues, would probably get a dismissal or a guilty probation, ends up facing up to 5 years civilly committed, where the motivating, the impetus to it is the competency that in the 16F.
His civil commitment is only based on the fact that he's mentally ill and dangerous. It has nothing to do with his criminal case.
I
No,
understand.
it's not
That's why I
based, it's
asked
not
you the
based,
question,
when
yeah.
civil commitment here is based on his incompetency.
Right. However, in Massachusetts, you cannot be civilly committed based solely on your incompetency. So in a way, again, it runs parallel. So while a defendant could have that case open for a duration of time, through the sheer fact that he's incompetent, he could never be adjudicated and found guilty and have those sentences that you've proposed. Just for a sheer competency, the Commonwealth will never be able to adjudicate that person.
But
So
should he be held, though? I mean, if our criminal justice system doesn't try people who are mentally ill, I mean, can't, because they're not competent, I mean, I am not trying to equate mental illness with incompetence, but doesn't try people who are incompetent, is it fair to hold that person in Justice Lowy's example for 5 years?
Well, he's not being, I think I'm not understanding what you by being held. You mean civilly committed?
No, I mean like held pre-trial.
Well,
You're talking about?
Well, not just that. I'm talking about that I saw this all the time in the district court. The defendant gets caught up in the tide of an issue of competency, and there is perhaps a danger, and all of a sudden they're in custody, civilly or criminally pre-trial, way longer than they would have been if the case could have resolved if they'd been competent to plead guilty. And I think that's part of the concern that's led us to this case.
right, but they're totally separate. If he no longer is mentally ill or dangerous to himself or others, he will not be civilly committed, independent of his criminal case. So while if either of those prerequisites fall away, he will be released from civil confinement, and if he remains incompetent, his case will still remain open. His confinement civilly has nothing to do with whether or not he has a pending case. There are plenty of instances, and I think the legislature contemplated, and that's why that 16F, it's not a prerequisite to be civilly confined.
When is an interest of justice early dismissal warranted?
I think that is a contemplation of somebody that might be mentally retarded and may ever become competent. And I think that it's a balancing. I think 16F is a balancing, and that provides the safety valve. So in the time limit, the time provided by the calculation, if it's determined whether or not someone will never be restored, it allows for the possibility for dismissal, perhaps even before the dismissal date
Let's take
provided
this
by the
case.
calculation.
I mean,
Can
can you say with a straight face that there's a real possibility that he is going to become competent between now and June or July of 17?
Actually, Your Honor, he has been since evaluated by the same doctor who has now opined that his likelihood of restoration is not likely to happen. So if that is different from the findings that were before Judge Coffey when he made his decision. So that would have to be remanded, I think, for an additional evidentiary hearing, for perhaps a separate evaluation of that doctor's opinion, and perhaps it would result in the dismissal of the case in the interest of justice.
Now, let's assume a miracle happens and he's found to be competent. He goes to trial, he gets the maximum sentence. he'd go to the 30 months, he'd be released, would he not? Because he'd already served the 30 months.
I would suggest that he would have to probably serve it because the way the statute is written, it delineates the time that would be actually strike that. I think the statute talks about that he would get some credit for the time he's been in Bridgewater.
He's on bail anyway, right?
I think so, yes.
So he'd probably get credit.
Credit. I think he would get credit, especially for the time
We're
he's
in
been
the unusual
Bridgewater.
situation that if a miracle were to happen, he would go to trial, and the worst possible thing could happen, which is that he'd be convicted and be given the maximum. He'd walk out of his he would walk out of his facility and then arguably then be civilly committed, if he were civilly committable. But he otherwise could walk out.
That is a possibility.
So he is worse off right now because he is incompetent.
Well, not necessarily. I think that the point of the statute is allow for the Commonwealth's interest to, at the outermost limit, for it to adjudicate a case balanced against those of the defendant having a case open. And because it deals with mental illness, it's a murky water, and that the bright line allows for the Commonwealth to pursue its interests with the safety valve of the interest of justice. And the fact is that if it is a shorter amount of time, as the defendant's suggesting, there's a possibility that there could be a dismissal of a charge that is actually premature, as in perhaps there's not enough time for the appropriate treatment of that person and not enough time to determine whether or not that person can be restored, and therefore truncating the government's interest in trying to adjudicate the case and possibly indict somebody that is incompetent when they become competent. So I really think it's a balancing, and I think...
Is a dismissal under 16F with prejudice?
I think it's not with prejudice. It runs independent of the district attorney's actions. It has nothing to do with whether or not we use our discretion or not. That the outermost limits would be by the statute of limitations. So if at any point after the 16F date arrives, if that defendant later becomes competent, I suggest that there would be an opportunity for the Commonwealth to reissue charges.
Okay, thank you.
Thank you.